Thank you, Anna. Thank you, Yari, Sarah, all of you for being here today. Really, it's a pleasure for me. I know you had Ignacio de Castro yesterday as a speaker on ADR, arbitration, and intellectual property. So today we will be discussing a topic that is quite new, and it's about gaming. It's about esports, video games, and the disputes that happen around this environment, this industry, and how we can apply all the knowledge that you by now have on different ways to resolve disputes out of the courts, either by arbitration, mediation, expert determination, and many other procedures. We can all get a bit creative and try to find suitable solutions that are tailored to the specific industry. So my question now is, do you play video games? Yes, are you familiar with the gaming industry and what esports are? Okay, so esports, you know, we can see in this picture a group of players, different teams, big audience, and what's happening is they're playing video games in a competitive way and in a professional manner. So we're all familiar, of course, with sports competitions. In sports competitions, what we can see is that there are teams that wear clothes with logos, that have contracts, that have a competition among the different teams to win prizes. We have sponsors. We have streaming, which is, you know, what we know as broadcasting in sports competitions when we watch Football World Cup, for example, or any other big competition. So all of this is happening, and it's happening big time. We can see in some countries that there are full stadiums with 40, 50,000 people attending this competition. And of course, disputes happen, right? This is the same as in any other industry. Now, are the courts the most suitable places to go and resolve disputes when you are, for example, in the middle of a competition that lasts for a few days and you need to resolve a dispute in a time and cost-effective manner and with specialized knowledge? Perhaps not. I haven't heard of any place yet where we have courts specialized, national courts specialized in sports, but perhaps in the future we may see this. So again, by now you might be very familiar with how arbitration works, and I'm going to take the liberty to expand also another what we call ADR, alternative dispute resolution mechanism, because depending on your strategy, if you are, for example, a lawyer representing a team, or if you are a dispute resolution professional and a mediator, depending on the different strategy of the parties, you may want to use one or the other, or at the same time maybe combine them and have perhaps a first instance when you try mediation, and if you don't manage to resolve the dispute, then you can move to an arbitration or an expedited arbitration. One thing in common for all these procedures is that they are consensual, they're voluntary. So we cannot force anyone to use them unless they have agreed to do so. How can they agree to do so? Well, by now, again, you might be very familiar with how arbitration or ADR clauses have to be drafted. There, we don't need to reinvent the wheel. There are many model clauses that have been tested that work, that are included in different kinds of contracts, of commercial contracts that can be used also in this industry. Now, why would we consider ADR as an option to resolve disputes? You see here a list of topics are quite, I would say, logical, right? Cost and time. Every time we run a survey in different industries, and we had one present some results focusing on the digital environment, including video games, and they are always time and cost are the main considerations when selecting your dispute resolution option, and that's of course normal, right? And when we talk about time is also cost, because the longer it takes to resolve an issue, a dispute, the more resources we may have to allocate, and that has a big impact on our business or on our commercial activities. We see also an internationalization of in this case, intellectual property, digital content. I was just mentioning the possibility of streaming these competitions, and people from all over the world can be watching. So you may have rights to broadcast or to stream in certain countries and not in others, or to show certain sponsors. So that makes this experience international. So the local courts might again not be the ones with the jurisdiction or the most suitable option to resolve this dispute. Then we are talking about a very technical and specialized area. So here, not only legal knowledge is needed, but also the expertise in the industry, especially if you're helping parties to reach an agreement with mediation, for example. So you need to know practices, you need to know how the deals are done in the different areas. So that's why the experts in esports, gaming, intellectual property are needed to resolve these disputes. Then we see that everything is happening too fast, right? So it happens in our life when everything is one click away, and if it's not one click away, we get a bit nervous already. So in this competition, for example, if there's a dispute, imagine that there's a player and the player has not consented to use his image in the course of the competition, in any advertisements. So this can have a serious impact in this area. So we need to resolve these disputes through mechanisms that are time efficient, that are fast, that can be used in a very practical manner. And of course, confidentiality can be very important. And here we can have some, for example, trade secrets. We can also have issues related to the reputation of the parties. Right? No one wants to be seen as a problematic business partner, or for everybody to know that you are involved in disputes. And arbitration mediation, they allow us to do that and to have these provisions. Now, what we observe in this industry and in IP in general, because of course the video games and the esports industries, they have a strong connection with IP, and the industry has surpassed the music and the cinema industry together. So when you play in a video game, you can see that there's of course copyright, there are issues related to the design, there are issues related to the music. You can have trademarks to be present in the video game or in the gaming platform, even hardware, right? We're using consoles, we're using different physical elements like virtual reality, for example. So all these matters are related to intellectual property and most likely are protected. So we are seeing an increase in the number of cases. We're seeing an increase in the number, at least, of consultations, because sometimes, it's quite a new industry. So when you include a clause in a contract, you may not face a dispute straight away. It may take some time, and you have a good collaboration with the other party, and eventually it happens. So that may happen a bit later in time. But for now, what we're getting is consultations on how can I resolve this, I have this dispute in my team, I have this dispute about the use of a license to use a video game in a competition, etc., etc. We also see that there's more engagement from companies, from individuals to show willingness to participate in alternative dispute resolution procedures. And they're happy to go out and say that ADR is positive. And I'll share with you a very recent development. Last week, WIPO, in partnership with ISIC is the Esports Integrity Commission. So we launched a new tribunal, the IGNIT, the International Games and Esports Tribunal. So it's the first tribunal that specializes in video game and esport. And this is, again, very recent. That happened last week. We've been working with our partners, ISIC. They take care more of the issues related to integrity, and this could be, for example, match fixing, could be cheating in competitions, could be hacking, doping. You even have e-doping, somewhere like somehow hacks the system to take an advantage and, I don't know, go through walls in a Counter-Strike game, for example. So all these things can lead to sanctions, and the sanctions are applied by ECB. So they take care of that, and we take care of the commercial and IP matters. There's a very recent development, and we are working with the community, we're working with the different stakeholders to make this happen and to see and to tailor it really to the needs of the industry. We also see the use of multi-tier clauses or escalation clauses. So, for example, mediation or expert determination as a first instance. And if the parties are not satisfied or don't fully settle, they can move to an arbitration or even to the court. Sometimes they choose to have a mediation and then go to the courts. Still in a phase of changing culture in many companies and for many stakeholders to understand the advantages of using arbitration. And I think that courses like this are very helpful for that, to raise awareness and to educate younger generations to use more and more alternative dispute resolution mechanisms. We can also see in some countries that there are schemes by government agencies. So we work, for example, with the Ministry of Culture of the Republic of Korea, and gaming is a big topic over there. So we have a mediation promotion scheme that the government allocates some funds to help the parties know sufficient resources to use this ADR mechanism. Legislation is also changing. Legislation, IP, copyright, trademarks, patents, is changing in many places. We have, for example, new legislation in the EU, regulations, directives that are related to the digital market, imposing, for example, certain obligations on platforms where you share your content, you use your social media, you upload content, you can stream video game competitions. So once you accept to upload your content, you are accepting the rules and the terms and conditions of the platform. So the platform has to ensure certain standards. If it's happening in the EU context, they need to offer dispute resolution mechanisms internally. And if you're not satisfied with that, then you can go to an out-of-court mechanism. And WIPO is working in that area, and it will have an impact also in the gaming industry. So the last point here would be what we call the model agreements. Right? So we have worked with some governments in other areas, and licensing, for example, research and development, to offer model agreement, model contracts that include dispute resolution clauses, focusing on arbitration and mediation. So that becomes some sort of standard, also endorsed by different government institutions to help, especially the SMEs, the individuals, the entrepreneurs, the inventors, the artists, to use these contracts that were drafted by experts. So these are some of the developments to give you some context. You probably already cover this differences between litigating in the court and using arbitration and mediation. So this is a very simple overview. And again, it's not that there are good or bad options. It's all about the strategy. It's all about the needs if you as a user, or your clients, if you are a lawyer, if you're a legal counsel in a company, to understand how this mechanism works and what can be the most suitable option to resolve your dispute. You're familiar with WIPO already. I only have to say here something about the Arbitration and Mediation Center. So the center was established in 1994. So it's been more than 30 years. If you think about 1994, the internet was just starting. We probably didn't have internet in our house or in our offices. And WIPO has adapted to different circumstances. For example, with the dispute resolution procedure for domain names. Domain names, internet addresses, and that was a very disruptive technology at that time, when you would only have like one domain name. For example, you had Coca-Cola.com, there's only one Coca-Cola.com, and someone registered without the rights. So how can Coca-Cola show a better right? So WIPO worked on tailoring that, and that system is still in place, untouched. So it's been on for more than 25 years. If you think of the evolution of the internet and the digital environment in these 25 years, you can see there is a very solid and robust mechanism. We have received, last year, more than 6,000 cases in that area. It was the second busiest year, and the previous one was the busiest. So this is just to show that when we design mechanisms, all of us, when we, as a community, participate in helping in industry, if we do a good job, these mechanisms are, still in place, and they can be very, very useful for the different. In this case, the trademark owner. In the case of esports, for the esport and gaming community. So there's always something to be corrected. There's always something to be adjusted. It's an agile system. It's an agile process where the more you learn about the industries, the more you can help them to go ahead. The rules here, I'm only going to add that the WIPO rules are flexible rules, so they were designed taking into consideration the main standards of arbitration, mediation, expert determination at that time. We're constantly updating them. So nowadays, the procedures can be conducted entirely in a digital manner. So before it was necessary to send all these huge paper copies all over the world. So that has helped really to expedite the resolution of disputes. And if there's something that we could say positive about the COVID pandemic, for example, is that we all got used to the video conferences, right? Today we have a lot of participants online. This was not maybe so common 5 or 8 years ago. So nowadays we're all used to having these meetings through different video conferencing services. And at WIPO, I would say that almost 100% of the cases now take place in this digital environment. So also the lawyers and the parties and the arbitrators and mediators feel comfortable generally and with using this technology. So that helps a lot to reduce the time and the cost of dispute resolution mechanism. I mentioned this survey that we conducted a few years ago. The survey focused on disputes in the digital environment, including in the gaming space. We have 1,000 respondents, so it's a good sample with representation from more than 120 countries. And we got a lot of quantitative and a lot of qualitative materials coming out of this survey. And here I'm only going to share one of the results. What we can see here is the question is, what is your perception? They use, but your perception, what do you think about the different dispute resolution mechanisms that are available for IP disputes in the digital environment? And mediation and conciliation is no surprise, so right as the highest. Arbitration did very well too. Court litigation, depending on the jurisdiction, in some countries the courts, of course, are very expedited or specialized, so the local users are happy with the systems. But here, I think it was interesting to see expedited arbitration, which is a shorter, less complex version of arbitration that we offer at WIPO, for example. We have, together with expert determination, quite an interesting percentage of respondents that say, I don't have an opinion about this. And this, we can infer that it's because maybe they're not familiar, they don't know what it is. So it's our job also to bring into the attention of the user, say, wait, if this is a smaller dispute, less complex, you have the chance of using an expedited arbitration version. This is very much used in the IT and software industries. That's what we observe, right? When you need, for example, if it's in a software development contract, that can also be related to the development of a video game. There, what we can see is that there's always a need to, it's like if you're making a movie, you have a deadline to go into the market. So if you face a dispute, you want to get rid of the dispute in a fast manner. So then expedited arbitration is a preferred option. Expert determination also. Expert determination is a bit of an underused procedure. It's not arbitration. So expert determination doesn't have, a result, an award as a result. not enforceable on the New York Convention. Or here, what you're looking for is a technical opinion. There's someone that tells, for example, you're developing a video game, you're the company developing, you have the client, and then the client says, this is not what I asked for, and then what does the contract say? And then you need an expert to determine really, okay, this is what you asked for, or this is not what you asked for, and continue. So it's very much used as in an agile manner. It's used in the construction industry, for example, when you're building a flat and you're stuck in the middle. You need to resolve a dispute, an expert, and then the parties agree in advance to accept whatever the expert decides. So that's another mechanism that's interesting to keep in mind. I mentioned that in the video game industry, we can see a lot of IP involved, and of course, a lot of IP disputes. Copyright, there we can see, for example, the avatars, the characters, the design, everything related to music synchronization, for example. So you need to clear all these rights to be able, like in a movie, to use them. You also have, of course, the licenses to use the games. That's very important, especially in competitions. So you have a publisher that is the owner of that game and needs to allow you, normally by exchange of payment of royalties, to use the game in the competition and to make sure that you're not violating any copyright. This can have a massive impact if you don't have all the clearance. For example, a competition can be cancelled because of this. So you need to be really aware of that. Streaming, again, it's another important one. As we know, there's a lot of, sometimes quite a few millions of people watching this competition or these events online, a lot more than what you think. So it's really, really big. And there are a lot of advertisement, you have sponsors, etc. So the business side is also patents, all related to everything that is related to the physical equipment that you need to play the games. We can also talk about industrial design and how things look like, if you have the shape of your man to play a game, for example. Trademarks, there are more and more present. So you can see in, a few years ago, we had the hype of the metaverse and the NFTs. And so we've probably all heard about them and how different brands were, for example, buying an online presence, buying land in different metaverse to have a virtual store, or in the NFTs to mint these NFTs that then were commercialized at very, very high prices. So trademarks, of course, always a topic that comes up in disputes. And trade secrets can also be there. And this is a very sensitive topic. And here, perhaps, just to highlight that the WIPO arbitration and expedited arbitration rules have a special procedure when there are trade secret or confidential information involved, how to disclose it to make sure that if you disclose it, it's not a secret anymore, so it might lose a protection, or protection might be affected. So there are safeguards, there are procedures to make sure that that doesn't happen, and that was a very innovative provision that the WIPO rules included many, many years ago, and that they made very suitable for IP disputes. Now, the potential parties in disputes, you have a lot of stakeholders. You have the publishers that own the games, will be the one perhaps organizing the tournament, competitions, but also licensing it to whoever wants to organize tournament organizers. You can think of, for example, the trade fairs, right? When you have, here in Basel, you have quite a few very famous fairs, watches, for example, when all the different exhibitors, they need to agree to certain terms and conditions to be present there. That includes normally issues related to IP. For example, in Geneva, we work with Panexpo, which is the exposition center, conference center in the city. In the Salon de l'Auto, which is the car show, very famous car show. And there are disputes that happen because maybe an exhibitor is using the logo or the brand of another one without permission, or many other issues related to designs and copyright. So there's a panel of experts on standby. There's a special procedure that WIPO developed in collaboration with its experts. So if there's an issue, in 24 hours, the issue has to be resolved. There are usually a few cases happening every year, and normally the parties settle. And this was a very positive development in the sense that before you would have to go to the courts, you have to get some order from the court in Geneva. You probably need the police to go and seize some products, so it was not a very good reputation also for the whole conference. So this procedure is confidential, expedited, and in 24 hours has to be resolved, works very well. So that can also be applied in the industry of the esports, right? And there we can think of what's called a dispute resolution board, to have experts on call, and there's a dispute, it's referred to the expert, and whatever the expert decides is accepted by the parties. Then you have, like the more common stakeholders, anyone owning an IP right that might be involved in a video game can also have a say in these matters. You have the teams, you have the players, so the players are professionals, so there are all these contracts and these conditions. So it's quite an interesting ecosystem, and again, it's developing, it's growing. So we are understanding the needs, and we are offering these solutions in the best way that what we can. At WIPO, we have designed, for example, some specific contract clauses to include in the terms and conditions of the tournament by the organizers. So we are promoting these clauses. They include references to either mediation, expedited arbitration, expert determination. So there are different options, and the parties can choose and see what to do. Then we also train experts. Sometimes it's more common to train experts in the subject matter to become arbitrators or mediators than the other way, right? Because you need here a substantive knowledge. You need here people that know, lawyers that know about the transactions and the practices in the industry. And sometimes we need experts that are not lawyers too, technical experts. So all this panel is growing, and we very much, look forward to start receiving the first cases in this area. Now, we talk about mediation, just a few pointers to keep in mind. We use mediation. In mediation, you will have a neutral intermediary, mediator, that won't be able to impose any decision. It's not a decision maker. If you're looking for a decision, then mediation is not your procedure. There, it's more based on the business interest, the parties, and how the parties can try to get what's called a win-win solution, to compromise and get that solution. And if you're not happy with the mediation, then you can always step out and try another more formal dispute resolution procedure. So when would you use mediation? For example, when you're negotiating a license. So if you want to use the game, it's not about winning or losing. It's about being able to use the game in your competition. So mediation can offer this forum. And at WIPO, we have this, what we call a unilateral request of mediation, which is basically inviting the other party through WIPO to consider this neutral forum as a place to try to reach a solution. And it's very much used in infringement situations, when someone is using an IP right without the right to use it, then in this mediation can try to negotiate some sort of authorization, some sort of license. We talked already about the role of the mediator. So here what is key to remember that it's not a decision maker. Arbitration, you're very familiar with arbitration, of course. So here we are looking for decision, and this decision will be final, will be binding. So that can be positive, of course, if we prevail in the case. If not, might not have the chance to appeal this decision, or might be able to attack it for certain matters. But it's a one round, let's say, one instance procedure. And here, of course, arbitration is more technical, it's more legal. You need to be mediation, sometimes there are no legal representatives, no lawyers. In arbitration, you will need someone familiar with how arbitration works and all the preparations, how to prepare a hearing, the submissions, the evidence, etc., etc. So the threshold is a bit higher. And what we observe is that more use, of course, by multinational companies in larger disputes. An example is in the pharmaceutical industry, which of course is very big here in Basel. So we can see that there, when you have patents and large sums in dispute, arbitration, normally with three-member tribunal, is used. While in, as I mentioned before, in industries like in software matters or even in the video game, we notice more the expedited arbitration versions. So why arbitration? Well, you need a final decision, still confidential. So if you want to use it as a precedent, then you are not going to be able to do so, right? So that you may have to go to the court and get a decision from the courts and say, okay, this is how it is in this jurisdiction. While here, disadvantage, of course, is that you don't have access to other awards or other cases, so you cannot see how similar situations were decided. But at the same time, arbitration also offers, and at any stage, possibility of settling. In WIPO, we see about a third of the arbitrations end up in a settlement agreement. In many cases, what parties do is they go through the process, they file all the evidence, the case is ready to issue an award, and then maybe either the tribunal offers the party the possibility of trying to get a settlement, or in some cases the parties spontaneously do so. But then they ask the tribunal to issue a consent award, so an award that will include this agreement. So if then a party does not honor the agreement, well, you can benefit from having an award or another mechanism for the enforcement. And confidentiality, again, here, at least in the WIPO rules, the provisions are very strong. Unless all parties agree to disclose any information related to the case, then the case should remain confidential. The role of the arbitrator here, of course, is different than in mediation. So here you have someone making a decision based on the rights and obligations of the parties, so it's not more legal in that sense. And well, you know all the matters that can arise with the enforcement of the awards, or trying to get an award annulled, for example, and so on. But the conclusion for me with arbitration is that it's more used in larger disputes, more complex matters. And then finally, expert determination. As I mentioned, expert determination offers the possibility of asking an expert about a very specific matter. And we have seen this used, for example, in issues related to the value of IP rights, like imagine a company buying another company, the second company owns patents, and they cannot agree on the price of the patents, then an expert can do a valuation and the parties may accept what it is. So this expert determination can be binding or non-binding. When it's non-binding, it's more like an opinion. So it's also used sometimes to get the opinion of an expert in the context of court proceedings. So in some cases, and we have seen this in the courts in Singapore, for example, where the judge appoints an external expert, and through this WIPO expert determination procedure, they have this opinion from the expert. The role here, again, you will get a decision, not enforceable, not final and binding. If a party does not comply, you will have to go to the courts to get, the enforcement needed. Some examples of cases that we have seen WIPO, this is all quite new. The slide is a bit packed, but it's just, for you to understand that we are starting to see in the last few years issues related to video games and gaming, esports. And the issues are related to many different matters. We talk about streaming, so streaming rights, the possibility of using games, the issues between members of the team and the owner of the team for the lack of payment. It's a team that won a competition and the owner didn't pay the members of the team. Then we see also matters related to the use of logos, trademarks, for example, sponsored in the equipment that is used by the different teams. We have seen issues related to the organizations, the tournament organizers with the participant for violation of terms and conditions. So they are mainly of a commercial nature, and most of them related to WIPO. WIPO has quite a large program on video games, and normally dealing with developers from like the really big publisher, big companies to indie producers, smaller independent game developers. And as part of that program, there's always some module or some information that is about dispute resolution. So we're trying to help raise awareness among the whole ecosystem to include these mediation and arbitration clauses in their contract. I'm going to now finish with this. I think I mentioned already about the IGET, this tribunal that focuses on this industry. This is a joint initiative by WIPO and the Esports Integrity Commission. We are building all the infrastructure around it. We have received already a few consultations on stakeholders that have disputes or that they want to use these clauses in their contracts. So it only came out publicly a week ago, and already we have seen a lot of good feedback and results. So of course, it's not a coincidence, because before launching this, we, together with a group of experts, including in arbitration too, what we did is we did all the research and we did all the market analyses to see whether it was worth having this initiative. And we participated in some of these competitions, which was quite a personally very interesting experience to be there, seeing teams playing these games for prices of $1 million for the winner, for example. So it can be quite interesting. And yeah, so it's an industry that needs all this infrastructure, that needs solutions that are fast, that are fair, and in particular, that are delivered by experts. So with this, I think I'm going to conclude this first part, and apologies if I exceeded my time a little bit, but there are quite a few things to be said about this. And I thank you for your attention. I'm happy to reply to any questions.